Welcome to Law Pulse YouTube Law channel. Today, let us discuss about the Droit administrative under administrative law. The key features are implications of Droit administrative, comparison with common law, the landmarks cases connected to Droit administrative, and the conclusion rather. In general, what is Droit administrative as such? Let us discuss about the general features of Droit administrative. It is a distinct French contribution to public law, the two different kinds of laws with two different codes, emphasizing the special legal regime for public administration. The Napoleon Bonaparte rather prompted this kind of legal system in France. And again, this Droit administrative has inspired the developments in administrative law worldwide, including India and the other countries also. The highest being of Droit administrative is called as Council of Estate or Council Edet. So these are the general features of Droit administrative. Let us discuss now about the key features of Droit administrative. So here they separate jurisdiction. This is a significant feature. The separate jurisdiction is the administrative disputes are not handled by ordinary courts, and the special administrative courts deals with the issues between public officials and the citizens. So this was the principle of law during the time of Napoleon Bonaparte, and the administrative disputes are exclusively dealt by some courts which are called as tribunals as such. That we will discuss in the thereafter. And second one is the supremacy of public interest. And this supremacy of public interest is public interest takes precedence over private rights. The state may perform acts not permissible for private individuals. So this is the supremacy of public interest rather. The state accountability rather. The state can be held liable for the acts of agents but under principles of different from private law. And fate personal or personal fault or fate to deserve the service related fault principles are used under state accountability. The judicial creativity rather. The system is largely judge made laws, especially through the rulings of the Council of Edet. So this is the judicial creativity, and it is not codified like a civil law. So these are the features we can say. And coming to this comparison with the common law. The common law in the countries like India or in United Kingdom, the administrative law is the part of the ordinary legal system. There is no separate hierarchy of administrative courts, and the India follows the dicey rule of law, which discourages the separate body of administrative law. Both of the tribunals, the public interest litigations and judicial review under Article 32 and under Article 226 in India reflects some features similar to Droit administrative. So these are the important factors, the comparison of common law with the Droit administrative, where the Droit administrative has significantly and strictly followed in the country France as such. Then coming to the implications of this Droit administrative as such. The implications of the Droit administrative are dual legal system. The dual legal system is nothing but the redressing of the public grievances by one court and the redressing of the officials and the government in another. The dual legal system as such. It creates dualism in legal systems, administrative and civil rather. It promotes specialization in dealing with the government related disputes and protection against the arbitrary state actions. So this is significant rather. And coming to the point, offers remedies to the citizens against misuse of power by the administration and balances the state sovereignty with individual rights as such. And coming to the efficient public administration under the Droit administrative, it enables the flexible and pragmatic governance. The state is empowered to act swiftly for public welfare and then judicial review of administrative actions rather. The administrative courts can annul, suspend, or modify administrative acts, promotes legality and accountability in government actions, the doctrine of act of government, and certain acts of the state like foreign policies and national security are non-justifiable. So in total we can say the efficiency of this Droit administrative in public administration is in the case of France, where the cases or the allegations against the public servants are dealt by the tribunals, by the courts, or the tribunals uses to pass the various directions fixing the accountability of the public servants as such. So, in total, we have to discuss here in the case of the Droit administrative, the landmark cases which has been documented in the legal history. One is connected to Bolko case of 1873. So this is a very important case relating to the administrative, Droit administrative. So this is the cornerstone of Droit administrative. It ruled that the state liability in administrative matters must be governed by special administrative law, not by a civil law. So this is the observation made by in this case during 1873, which was pronounced in the tribunals of France rather. Coming to the other case, Cadet case 1889, which establishes the Council of Edat is the final authority in the administrative justice. The Council of Edat is the final authority under the administrative law. And it says whatever the pronouncements, whatever the rulings made by the council Edat is the final authority in the administrative justice. Coming to the Indian cases of administrative law, the Droit administrative is also marked under the case of A.K. Kriyapak versus Union of India. Here the issue was the principles of natural justice. Here the selection committee included by a person who was also a candidate for the same post. Then the courts have ruled that the administrative actions affecting the rights must adhere to the natural justice, even if not a judicial or quasi-judicial. Administrative discretion is not absolute. This is very important case in the administrative law and Droit administrative as such. And coming to the Maneka Gandhi versus Union of India case, rather, here the issue was right to travel abroad, the principle of fair procedure under Article 21. This was the issue before the Supreme Court. And the facts of this case is the Maneka Gandhi's passport was impounded without giving her a fair hearing. And this was questioned before the Supreme Court. And then the Supreme Court ruled that the procedure must be fair, just, reasonable, expanded the scope of the Article 21 and strengthened the judicial review over executive discretion. So this is also a very important case with regard to Droit administrative under administrative law. And again, the landmark case of Keshwanand Bharti versus State of Kerala. Here, the issue was the basic structure of doctrine rather, and the facts are the challenged constitutional amendments of affecting the property rights of Edanirmat. So here, the Supreme Court, the largest constitutional bench constituted at the time, and held that judiciary can review even constitutional amendments if they destroy the basic structure, ensuring the checks on administrative powers. And the other important case in Indian legal history is Indira Nehru Gandhi versus Raj Narayan. The issue was the rule of law and equality rather. The court had that declared the election laws are unconstitutional, which gave blanket immunity to the Prime Minister, reinforced that no one is above the law, including the administrative authorities. So these are the very important cases with regard to the Droit administrative principles of law, which was first founded, which was in France centuries back, and thereafter the few democratic countries have adopted, and a few democratic countries have followed the Droit administrative rules partially as such. Now let us conclude the topic Droit administrative as these landmark cases from the bedrock of the administrative law in India, affirming the public administration must act fairly, reasonably, within a limit of law, and it is the echo, the spirit of administrative, Droit administrative, by asserting the public accountability, protection of individual rights, and judicial control over the administrative actions.